Hey everybody, estate planning attorney Paul Rabelais here. Let's jump right in. How to get letters testamentary, specifically in a Louisiana succession. So struggled with this, state specific thing, but every state has their own procedure. And so I didn't really want to speak generally. And I've handled successions, thousands of them over the last 3 decades. So we're going to focus on how to get letters testamentary in a Louisiana succession. But if you're in another state and you want to figure out how to get letters testamentary or letters of administration, could have a couple of other names to it, depending upon your state. I know that your state's procedure is similar, but I'm going to go through the very specific procedure for Louisiana. So we got a lot to go over. Hey, Susie, great to see you. Good to see your smiley face. All right, so here's what normally happens and what typically triggers this desire to get letters. What happens is somebody dies. I'm sorry about being blunt about it, but it's what triggers this stuff. Somebody dies, and that person's survivors might be a spouse, might be children, might be other heirs. Those people will often go to the deceased person's bank because they're thinking, hey, this person had a will, named me as an heir or named me as executor or named me in the will somehow. I'm going to go to the bank and I'm going to get their money. I'm entitled to it. So, hey, Susie, hey, Stephen, good to see you. Keep throwing stuff in the chat. Always, that's why we do it live, so we can have a chat. Keep it positive, good comments, questions, and experience. Let's keep rolling. So people, survivors, go to the bank. They're expecting to receive funds from the bank because maybe these survivors are listed in the will. And so they go to the bank and they say, my husband, my wife, my uncle, my father, my mother passed away. They had $50,000 in the bank here. We need to access it. So what typically happens is, the bank people start to get nervous. So they check with their officers at the bank. And then somebody comes back to these people and says, sorry, your husband, wife, mother, father, aunt, uncle, sorry, your father passed away. But I wrote down on this little sticky note what you need to get. And they'll write down maybe like the word letters testamentary or letters administration. The bank officer will say, that your father's account is frozen. We can't just turn those funds over to anybody. We need the official letters testamentary or letters of administration. And so it's funny. I think the banks all get together and they all decide that they're going to write down those words on a sticky note. I don't know how many times people have come to me with a sticky note that says letters testamentary and letters of administration on it because that's what the bank officer said they needed. So consumers don't understand that. They see the word letters. They think that the lawyer needs to write a letter or somebody needs to write a letter to the bank and say, hey, give these people the money. It's nothing like that. So I don't know why they call it letters testamentary and why that makes people think that somebody's got to write a letter. It's nothing like that. So there's a very specific procedure that must be followed. So that's when a lot of clarification is necessary for the survivors. How you doing, Williams? Sheila, great to see you. Wishes to you. So that's when we need to start clarifying some things. That's the whole purpose of doing this video is when you get sidetracked or when you get thrown a curveball and somebody says you need letters testamentary. Of course, you've never heard those words before. You have no idea what it means. Watch this video, either live or recording. We'll fill you in. Okay, so I will say oftentimes letters testamentary, which what it is, we'll get to in a minute, aren't needed. For example, if somebody has an IRA and they have designated beneficiaries, or maybe they have an account titled in the name of a revocable living trust when they pass away. The successor trustee can often access that account without needing these formal letters testamentary. So next, let's go over what are letters testamentary. Letters testamentary, and there's a couple of other names for them, but letters testamentary, those are legal documents issued by a court in Louisiana, issued by or wherever the probate takes place. And they authorize an executor to administer the estate of a deceased person. Bringing a last will and testament to a bank or to a financial institution isn't going to get you anywhere. After dad dies and dad's will says, I name Mary as the executor. She's my oldest child, and I leave my estate to my 3 children. It's not going to be good enough for Mary and the 3 kids to bring dad's original will to the bank and expect to get dad's money. The bank's not going to release the money. So this is the steps that the survivors have to go through in order to gain the court documents that a bank or a financial institution, or really any third party, might require in order to transact the estate of someone who died. So these letters testamentary, they empower that executor to manage and distribute the deceased assets according to the will. And I will say, even though the financial institutions will tell you, hey, sorry, your father passed away. We can't release his funds. We can't do anything with his funds. Your father's account's frozen. We need letters testamentary. Well, that's what they used to be called. But now in Louisiana, they're called something different typically. So I refer to what the bank needs as letters of independent executorship. Why are they called that? I'll tell you why in a second. But first, let's understand what the executor's role is. There's an executor in as long as a will was written correctly. I'd like to say in every will, but sometimes wills don't name executors. But if I read 200 wills, I'd probably have in 199 of them, there'd probably be some provision in the will that says I designate or I name so-and-so as the executor of my will, something like that. So the executor role is to carry out those wishes of the deceased person as they were expressed in the will. They handle all the financial matters like paying debts, distributing assets. And so these letters testamentary, or as I call them, letters of independent executorship, for a reason I'll explain in a minute, they are required to access the financial accounts, or for the executor to access financial accounts, required for the executor to sell property and manage the estate. All right, now let's get into this executor, letters testamentary, independent executorship thing. So in the good old days, and the good old days are prior to 2001, we had in Louisiana, we had what we call executors. And so when someone wrote a will, they named their executor. And when the person who wrote the will died, then the executor would come hire a Louisiana attorney. The Louisiana attorney would prepare a bunch of court paperwork, file all that court paperwork at the courthouse, and then a judge would, and part of that paperwork that gets filed in the initial round of what other states call probate, what Louisiana calls succession. Part of that initial round of the succession paperwork is the original will that the deceased person signed. And so the role of this first round of succession paperwork is to have a judge or judge's office review the will, make sure it meets all of the validity requirements, and read the will, make sure it meets the validity requirements, determine who the executor is. And then judges sign orders that say, hey, this will is valid, and I am confirming that this person is to be the executor. So a judge signs those orders. Those get shipped down to the clerk of court's office, and then the clerk of court issues several certified copies of what used to be referred to as letters testamentary. But in 2001, our legislature in Louisiana created a more simplified succession procedure. And if in the will, or under some other circumstances, but most, if not all, again, if I read 100 wills that have been written since 2001, probably 98 or 99 of them have some provision that says my executor may act as an independent executor. So this independent executorship thing was created by the legislature in 2001. And so now there are executors and there are independent executors. If someone is kind of just an executor and they're not an independent executor, then every act they take, whether they have to pay off a credit card that the deceased person had, whether they needed to sell some investments that the deceased person had and turn that into cash for the estate. If a person is just an executor, then they've got to go ask permission from a judge to take those certain actions. However, if the executor is an independent executor, now many of those actions that an executor has to take, sell a car that the deceased person had, sell a house that the deceased person had, pay bills of the deceased person, access the deceased person's bank accounts. If a person is an independent executor because the will says I authorize my executor to act as an independent executor, then the executor can take all of those actions independent of going to a judge and getting permission to take that action each time. Generally speaking, we always want the executor to be an independent executor because that it doesn't eliminate the court supervision, but it does minimize the court supervision that's necessary in a succession procedure. But because the independent executor can take lots of actions and not have to go ask a judge for permission each time they want to do something. So again, that's why, one of the first things we look for when I review a will after somebody died, of course, I look and see who the heirs are. I leave my estate to my 3 children. I leave $100,000 to my friend. I leave $200,000 to my church, and I leave the rest of my estate to be divided between these 4 people. Or I leave 60% of my estate to this person, 20% to this person, and 20% to this person. Or I leave $25,000 to each of my grandchildren. The rest of my estate I'll leave to my children, or I leave my estate to my spouse, or I leave my house to my daughter. So anyway, those are typically the first provisions that we look at when we review somebody's will after they die. But then the second thing we look at is, okay, who's going to be in charge of this thing? Who's the executor? So we find out, I name Mary as the executor. And then the very next thing we look for is the executor authorized to be an independent executor? So if they are, and in most wills written after 2001, there is that provision that says my executor may act as an independent executor. Now, instead of going and asking a judge to sign the orders and confirm the executor, and then the clerk of court issues letters testamentary, now these days we file the will at the courthouse. Judge confirms that the will is valid, but then the judge confirms that Mary is the independent executor. So again, that's a good thing. Independent executor is typically better than just being executor because less court permissions are necessary. And when a judge confirms someone as an independent executor, then the clerk of court issues what's called letters of independent executorship. And that's what we call it. So maybe other lawyers call it different things, but that's what we call it. All right. Chelsea, hey, good to see you. All right. So there's that whole, and nobody really understands it. Sometimes the banks don't understand it. Certainly consumers don't understand it. Outside of discussions about probate, how many times have you ever heard the words letters testamentary or letters of independent executorship? I bet many of you would answer that never. Okay, so let's talk about the precise procedure for getting those, what the bank's going to tell you they need letters of administration, but we know it's letters of independent executorship. Even though the bank says they need letters testamentary, they're operating under the old rules. And once you get them letters of independent executorship and they're going to have their legal department review it, they're going to say, perfect, turn over funds to the executor or the independent executor. So here's how you get them. First thing you have to do, and sometimes it's not an easy task, is you need to locate the original will. Not a photocopy, not an unsigned copy that was a draft. You need to locate the original will. How do you tell it's the original? Maybe you tell by there's the kind of raised notary seal on the signature page, which is often the last page. And so you can kind of feel and feel where the notary did the stamp thing. And that's a good indicator that you've got the original will, because if you can't locate the original will and all you have is a photocopy, then what our Louisiana law does is it presumes that the person whose will was written, if you can't find the original, then it's presumed that that person destroyed their will with the intent to revoke it. Now that presumption can be overcome, but more legal mumbo jumbo. So you want to make sure if you have a will, you want to keep it in a safe place. You want to know want to make sure your executor or your independent executor knows where to locate it when you pass away. So lots of times people have written wills and then they pass away years later, sometimes decades later, sometimes months later, and nobody can find the original will. So really important that that's probably the most important original that you keep. We can often get away with photocopies of trust instruments, and sometimes we can get away with photocopies of powers of attorney. Certainly, we can generally see people get away with photocopies of their healthcare power of attorney and their living will, but the rules are tricky and the courts are tricky when someone can't produce an original last will and testament. By original, I don't mean the first they did. By original, it means the actual document that they actually put the pen to the paper. All right, so you got to find the original will. And when you review that will, the will name the executor and it'll state whether an independent executor is permitted. If the will does not state something like my executor may act as an independent executor, then the executor name still can be an independent executor. You just got to get all the heirs to sign an agreement that says I'm allowing that person who was named in the will to be an independent executor, even though the will didn't say they were authorized to act as an independent administrator. All right, let's shoot over to Logan Dark Horse. I think I've seen that name before. I have a specific question. I had to take the executor power from a cousin that is a pill user. Okay, I like the way you used your little emojis here. Of my late father, I got awarded that in his will. He had, so we both got 50-50. Okay, so yeah, so a little ahead of ourselves, but sometimes someone's named as an executor and they either don't do their job or they don't do it well, or they abuse the power that they have as an executor. So that's a tough one. Again, more reasons to make sure you designate the right person as your executor. Responsible lawyer, good communicator, good relationships. Can oversee and do all of this fairly, this administration of the estate and distribution to the heirs. But sometimes you have an executor who goes rogue or just doesn't do their job, or they're just bad at it. So sometimes, in the event they aren't following the rules or they don't do their job like any other reasonable executor would, then other participants in the succession can file the appropriate court pleadings to an attempt to get that executor who's not doing their job removed. Typically, there'd be some court hearing, and a judge would have to determine whether what the executor did or didn't do, whether that was enough to justify removing the executor. And if they do remove the executor, then you got to look to the will to see if there's an alternate executor, because that person would step in, or if not, some other person would step in and be perhaps appointed as what Louisiana calls a dative executor. So lots of good stuff there. All right. And so let's see. Susie Aspen, I just wrote the CEO of Chase Bank. I know who that is. Her CEO of Chase Bank, because my mom's bank gave her executor powers when her son was, period. She was able to access mom's account to pay bills several times. All right. I think I'm lost you there, and I'm trying to kind of read things quickly and get back to my presentation. So I may take another look at that here in a minute. All right. So to become and to get the letters of administration or letters testamentary or letters of independent executorship, you get the will, you see who the executor is, see if it permits an independent executorship. You get with a lawyer, because all of these pleadings that have to be filed, no lay person can do it. It takes somebody with experience and know what words to put in all the pleadings and all that. So the lawyer files the will at the courthouse and asks the judge to sign the appropriate court orders. Number one, stating that the will is valid, and number two, confirming that so-and-so is the executor. Then those court orders go to the clerk of court. Clerk of court they issue letters testamentary if a person is an executor. They issue letters of independent executorship if a person is an independent executor. And if there's no will, then the clerk of court issues letters of administration. If someone dies without a will, somebody will step up and volunteer and say, I guess I'll be in charge of handling the settling of this person's estate who died without a will. If somebody died without a will, that person that a court appoints to oversee the settling of the estate is called the administrator. If a person has a will and designates an executor, that person who's in charge of settling the estate is the executor or the independent executor. So just same roles, but different titles. Now, sometimes, or I'd say every time, if someone dies without a will and somebody says, you know what, I'll be the administrator, that administrator really wants to be an independent administrator, because if they're an independent administrator, they can move things along quicker, get things done absent court supervision. The only way an administrator can be an independent administrator is if all of the heirs who are going to inherit under the intestate law in Louisiana sign off on an agreement that permits that administrator to be an independent administrator. Boy, that's a mouthful. All right, so that's the deal there. Now, when that petition is filed, asking a judge to order that the will is valid, asking a judge to confirm that the executor will be the executor. There's some other stuff that gets filed with that. So these affidavits of death, domicile, and heirship. Any two people who knew the deceased person will sign an affidavit. These affidavits get filed at the courthouse in lieu of filing death certificates. Many people mistakenly believe they can't start the succession until the death certificates come in. The death certificates often take weeks or months to come in. It's really a mistake if you're trying to move things along to wait until you get the death certificates to start the succession proceeding and get the executor confirmed, because you don't need the death certificates for that. Instead of filing death certificates, two people sign these affidavits of death, domicile, and heirship that say, I'm signing an affidavit that so-and-so died on this date. They were married or they weren't married. They had a will or they didn't have a will. They had kids. So all that's in the affidavits of death, domicile, and heirship that get filed with the petition to what's called probate the will, where a judge signs an order that the will is valid and confirm the executor. Okay. Once all that takes place, the executor is now confirmed. Clerk of court issues letters of independent executorship. Now there's a few steps that need to take place. The estate needs a tax ID number. In our office, we go through the process with the IRS to make sure the estate gets its, some people call it tax ID number, some people call it employer identification number, EIN or TIN. And so now let's say dad had a frozen bank account, or may have had 5 frozen bank accounts, and there was, $150,000 in those bank accounts. Now that independent executor can take those letters of independent executorship and a copy of dad's death certificate and bring that to the bank, and the bank's lawyers will review it. And now that executor will be permitted to open an estate account. Some people think an executor, the day after dad died, executor is named in the will, they can go to the bank and set up an estate account. They can't. You have to have those letters of administration, letters testamentary, letters of independent executorship, or letters of independent administration. The bank will not open an estate account without those clerk of court documents that get produced only after judges sign orders that the will is valid and so is confirmed as the executor or appointed as the administrator. But once you get all that to the bank, then they'll open an estate account. The executor is the signer on the estate account. They'll move the funds, perhaps from dad's frozen accounts, that $150,000 or whatever it is, into the new estate account. The estate account is a temporary account. While this succession proceeding is taking place, estate funds go into the estate account. Estate expenses, debts of the estate are paid out of the estate account. Ultimately, when this final succession is resolved and it's time to distribute the assets to the heirs, that estate account at some point will be closed, and there will be no more need for an estate account because all of the assets will have been dispersed to the heirs. But the letters, testamentary, letters of administration, letters of independent administration, or letters of independent executorship allow that person to deal with banks, to sell estate assets, to deal with creditors of the deceased and settle debts that they may have. The letters enable the person to open the estate account. Here we go. All right. Logan made a comment there, allowing the former POA post-death power without papers allowed her to call all family and friends and say, I stole all her son's inheritance. Sounds like an awful situation. Her son was executor, but every account was payable on death and he didn't want to do anything. Okay. Then we got Logan. She had turned it into a trap house. I tore tendons, cleaning it all up. Oh my. And okay, so you got a lot of stuff there. Susie, she had under $1,000 in her debit and savings, but my reputation is in the doghouse because, okay. So lots of stories. You get yourself in one of those, it's hard to get out of it. And, boy, those feelings often last for, many years, and oftentimes relationships are destroyed. So again, hope things can work out for the best, but that just gives us more reason about how important this process is of getting your affairs in order, designating the right people to fill the right roles. And again, you want to make sure you have people who are loyal and honest and get things done and good communicators and want to do the right thing. And so it's real important to have the right people in charge, and that way, stuff doesn't go south, as they say. All right, so just wanted to walk through that. If somebody tells you you need letters testamentary, and you're in Louisiana, really if you're in any state, but I know in Louisiana, probably time to see a lawyer. Have the lawyer draft the appropriate pleadings. You'll have to bring in the original will, and then court pleadings will be filed at the courthouse. You'll probably have to wait a few weeks because this stuff, takes its time to run its course. But ultimately, the clerk of court in the parish where the person who died, where they live in the parish, will issue these letters testamentary, if that's appropriate, letters of an executorship that you can use to deal with matters that are related to settling the estate of the person who died. All right. Hope that helps. We'll see you next time.